Hi, thanks so much for joining our webinar today. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful David Duree, an Illinois construction lien law expert. Today's webinar topic is don't sign a release unless it says this one thing. So without further ado, I'd like to introduce the fabulous David Duree.
Fabulous might be a strong term, but I have been practicing law in Illinois and Missouri primarily for more than 50 years, and I've settled many cases, both on behalf of the party paying the money and on behalf of the party receiving the money. So releases at first glance seem to be a pretty simple subject. But the title to this program is Don't Sign It Unless It Says This One Thing. If I would have to focus on the one thing that you should make sure of in signing a release, and I'm assuming it's a release after the events have occurred, meaning that you would be receiving some money, is to check the terms of payment, how much money you will receive, who the money will be paid to, who the money will be paid to by, and if there's any conditions on payment. And so this first category of topics is entitled Read the Release. A release is a contract, and just like any other contract, once you sign it, you're bound by its terms, whether you read it or whether you didn't read it. And the policy behind that is releases and other contracts wouldn't mean anything, written contracts, if a party could say, I didn't read it as an excuse for not performing it. So read the release. The one item to look for if you're receiving the money is the terms of payment. If you just glance through it and then sign it, you might later learn that payment will not be made until 60 or 90 days after you sign the release, or after something occurs in a pending lawsuit. So I would emphasize that's the number one thing to look for. Of course, the identity of the payee, you make sure it's payable to you or the party that you select. The identity of the released parties. Normally, releases will include the party you have a claim against, its attorneys, its agents, employees, and it goes on and on and on. And if you're not careful, you're releasing parties that you never intended to release. Now, as long as you're releasing them from your current claim, which you're getting paid for, it doesn't matter. But you might find some language in there which suggests that you're releasing claims that are pending but are not subject to the release if you're not careful. You have to determine whether you want an attorney to review the release or not. Obviously, if you're in business, you shouldn't have to have an attorney to review each and every release that you sign, but it's a decision that you need to make. And then you need to determine if the release is a partial release or a full release, and exactly what claims are being released. With respect to the matter that a release is a contract like any other contract, it's a contract that can be unilateral, meaning the other side presents it to you for you to accept, and you sign it and accept it, but the other side never signed it, they just presented it to you. Or it could be bilateral, that you sign it and the party paying you the money signs it, and maybe you're even releases claims against one another. It can be multi-party, you can have a number of parties involved in the release. But as a contract, it's subject to the same contractual defenses that any other contract is subject to. And there's really two types of releases to discuss today. The release that I was just describing is a release that after a claim has occurred and the other side is paying you money. So you know what your claim is, you know what's being released. But there's also a group of releases that are known as exculpatory clauses that require you to sign a release before the event in question. For example, if you're going to participate in some type of activity, the organization conducting that activity might have you sign a document in advance that says, if anything happens and you get injured, you're releasing the organization conducting the activity from any liability, otherwise known as an exculpatory clause. Just to give you an example of some of the contractual defenses that sometimes arise, and just a few of them. There's a case in Illinois from 2014, appellate court case involving a hotel, and the developer of the hotel had financial problems, construction stopped. The developer finally persuaded a new company to come in as the construction manager and to fill a couple of other roles. That company did some work both as construction manager and in these other roles as well, wasn't paid, so it filed 3 mechanics lien claims with the recorder of deeds. In Illinois, mechanics lien claims are filed with the recorder of deeds. In other states, such as Missouri, for example, they're filed with the clerk of the circuit court. In any event, in this case, after the construction manager stopped work and filed their 3 mechanics liens, the developer persuaded the construction manager to release the liens on the grounds that the developer, that would then permit the developer to obtain money from the lender, which had stopped making payments under the loan, and the developer would then pay the contractor, the construction manager, at least part of their lien amounts initially and eventually pay all of them. And the construction manager fell for that, signed a release, which the developer then filed with the recorder of deeds, and then the developer didn't pay the contractor. So the contractor refiled the mechanics liens, but there's a section of the mechanics lien statute that precludes you from doing that. So as a result, the construction manager lost his mechanics liens and didn't get paid because the release he signed of the mechanics liens that was then recorded with the recorder of deeds precluded him from refiling the mechanics liens. Now that's just an isolated case involving construction projects, but I believe most of you probably are involved in the construction business. If that's the case and you file a mechanics lien, I would suggest that you not let anyone sweet talk you into then recording a release of the mechanics lien under the promise of payment unless you get paid at the time the release is signed. Another background case that would apply to releases, this would be an exculpatory clause. There was a case in 2013 in Illinois, Spears versus Association of Illinois Electrical Contractors, or electrical co-ops, and the Association of Electrical Co-ops conducted a class for potential pole climbers in the utility business, utility industry, at a community college, but it had each of these students sign an agreement in advance that if they got injured in climbing the poles, that they would release the association from any liability. Naturally, this person then suffered an injury while trying to descend one of the poles, and the association tried to enforce the exculpatory clause. The court pointed out in that case that those kinds of releases involving, which are exculpatory clauses signed in advance, that there's several categories of people that are excluded from such exculpatory clauses. In other words, they cannot be enforced for public policy grounds, and it involved a list of such parties, and the criteria for identifying them. And in that particular case, the appellate court sent the case back to the trial court saying that the appellate court could not rule without additional findings of fact. The last case involving contract issues that I will mention about releases, there was a summary judgment issued in favor of a lender in a mortgage foreclosure case, and the lender had claimed in that lawsuit that it had signed and recorded a release of its mortgage, but it did it by mistake. And the trial court entered a summary judgment in favor of the lender. And a summary judgment means that the trial court determines that there's no material issues of fact in dispute, and the party moving for summary judgment is entitled to judgment as a matter of law. The issue there was the release of the mortgage that the lender recorded with the recorder of deeds, signed and recorded by mistake. And the appellate court reversed the summary judgment and said there are disputed issues of fact. You'll have to have a fact-finding trial before the court can rule on that, and pointed out that a party may avoid enforcement of a release where the release was obtained by fraud, duress, illegality, or mistake. And included in that would be the doctrine of unconscionability, that if a release or any other contract is so one-sided and so unfair that it cannot be enforced. So those are simply some of the contract issues that might come up even after you've read and signed the release. If you later decide that you're trying to get out of the release, you think it was unfair. I would ask Jessie if she would move on to the second slide. Another category of issues that comes up with respect to releases is almost invariably the party requiring the release and paying the money will require the party receiving the money and signing the release to include confidentiality and non-disparagement clauses in the release and/or settlement agreement. And on public policy grounds, I would submit that that's not a very good policy, but those conditions are enforced, and the party receiving the money almost invariably says, I really don't want to sign a confidentiality and non-disparagement agreement. However, if that's what I have to do to get the money, then I'll do it. Things to look for, first of all, is whether the release contains any of these non-disclosure clauses, meaning non-disparagement, can't say anything bad about the party that you just settled with, or confidentiality, you can't say anything about the fact that you settled with the other party. You can say that you settled, but you can't say the terms of the settlement. You can't say the other party paid you X dollars. And I guess the fear of the parties making the payments are that if word gets out that they paid this much money on this claim, then other people will decide to pursue claims against them or decide that their claims are worth more money. So the first thing to do is just see whether your release and or settlement agreement contains such clauses. And then it gets back to read the contract, read the release, determine the identity of the parties entitled to enforce the non-disclosure clauses. They shouldn't be enforceable by anybody other than the party paying the money or parties closely affiliated with it. And then determine the identity of the parties that are bound by the non-disclosure clauses. It may have language binding parties other than you really intended. And then determine the scope of the non-disclosure clauses, what can be disclosed, what cannot be disclosed, and determine whether there's any exceptions. Almost invariably, whether stated or not, there's an exception that if there's a later court proceeding and there's a court order or subpoena requiring you to disclose the terms of the release, then you're not in violation of the non-disclosure agreement by disclosing that information under those circumstances. And I would go to the next category, Jesse, the final category. The non-disclosure clauses, the confidentiality and non-disparagement clauses may provide for the payment of attorney's fees. And one thing you can ask for if you're negotiating the terms of your release is that if there's any alleged violation of the confidentiality or non-disparagement clauses, that attorney's fees should be paid to the prevailing party, not just to the party making the payment, the released party. That gives you a little more leverage in case there's a frivolous lawsuit filed against you claiming disclosure or disparagement or breach of the confidentiality clause, that if you prevail on that lawsuit, the other side might have to pay your attorney's fees instead of just a provision that if the other side prevails, you have to pay its attorney's fees. It gives you, it's some reason for discouragement of the released party from filing frivolous lawsuits against you, claiming that you violated the terms of the release. And then the final subcategory under topic 3 is whether there's any penalties other than the award of attorney's fees or actual damages for violations of the non-disclosure clauses. Typically, a confidentiality clause could provide that if the released party establishes that you breached the confidentiality clause, it would be entitled to recover its actual damages resulting from that disclosure, as well as its attorney's fees. But its actual damages might be minimum or hard to prove. It might just be a matter of the released party feeling that it's been slighted, but there's no real financial damage that it suffered because someone disclosed that it settled the case for $50,000, for example. But there can also be penalties put into these clauses. That's a good reason for reading them. They might provide for liquidated damages, which means that the parties assume that this is what damages the released party would have suffered, or it might even provide for penalties. And those kinds of clauses are especially of interest in the case of the settlement of a case where there were very hard feelings on both sides. There was a lot of acrimony, so that the party paying you might still want to get some type of revenge at every opportunity presented later on. Where those are the background facts, it's even more important to read those clauses before you sign the release agreement to make sure that you're not agreeing to some terrible penalty for a minor violation, alleged violation of the confidentiality clause. So that pretty much concludes my remarks. I'll be happy to answer any questions that you may have.
Thank you so much, David. That was incredible, some of the information that you were able to provide us. That was wonderful. There is a question that has come through, and it says, is there a standard form that must be used in Illinois for a release?
No. No standard form for any type of release that I'm aware of. Companies may have their standard forms that they use, but there's no statutory form. The main matter to determine is the actual content of the release, not the form.
Okay, perfect. And then another question that came through, and I think you've already touched on this, it says, if I sign an unconditional release without realizing it, is there any recourse I would have to continue protecting my lien rights?
Well, that would get back to that case I cited about the person who was climbing a pole in this class conducted by the Electrical Co-op Association and had signed this exculpatory clause, agreement with an exculpatory clause, which meaning a release in advance. In those kind of situations, if you sign a release and you sign it by mistake, then you have at least an argument in court that the release should not be enforced because you signed it by mistake. In those kinds of cases, you have an uphill battle if you're the one claiming that you signed it by mistake. Or you could claim that it was unconscionable, that it was so one-sided and unfair that it should not be released. Or you could claim other contract defenses that I mentioned before to avoid enforcement of it. But once you sign it, it's an uphill battle for you to avoid the fact that you signed it. Doesn't mean you can't get out from under the release, but the other side would have the advantage going into the dispute. I would say that.
Well, thank you. Yes, I think the key takeaway there is make sure, like you said, read that release. And if you have questions on it, seek legal counsel then for that to help you kind of review those releases. All right, that is all the questions we have that have come in. If you do think of another question that wasn't addressed, please feel free to reach out to myself or to David, and I'll be sure to try to answer your question as soon as possible. All right, so who is ready to win a gift? We are testing your knowledge here. If you can answer these questions correctly, go ahead and send them in the chat and we'll send you over a little prize. So go ahead if you think you know the answers to this, please chime in and we'll be happy to send you guys over something. All right, here are some of the SunRay resources to help you guys stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. There's deadline calculators, project information sheets. If you're working in a different state than the state of Illinois or a nearby area and you're not familiar with their lien laws, remember each state has their own unique lien laws, deadlines, and documents. So if you go onto our website, you're able to then see, okay, this is what applies to me, this is the document, this is the deadline that's enforced. Make sure that you are staying organized and on top of your documentation. All right, if you don't mind, take a moment to give us a Google review. We really appreciate any insight and feedback you can give to us. It helps better ourselves and our webinars and help to provide more relevant information and content for upcoming webinars of what you guys are looking to know. All right, so that is all we have for you guys today. Thank you so much to everybody who attended. We hope to see you guys at our next webinar. Thank you again, David. You really were incredible. I hope you all have a wonderful and beautiful sunny day.